G'day Kim, how are you?
Hi, I'm good, Andrew. Yourself?
Tell us about the teeth.
Oh, God. I've got a missing tooth. I'm getting orthodontic treatment. I'm just hoping I don't spit on you.
No, if you do,
But I think I've got a bit of a lisp happening as well. It's going to be very unattractive for a while.
All
So
right.
I hope you can't see it.
So don't stare at Kim's teeth, all right? That's the first rule.
I'll be talking with.
Look, a couple of things before we get going. I think we've got the Are You OK Day yesterday.
Yep.
And I think you and I have sort of quite mixed feelings about it, don't we? Because we recognise, well, certainly I recognise Beyond Blue, Black Dog, Are You OK Day are wonderful things for raising awareness that mental health is a very big issue. My difficulty is that I see it as social signalling, as you know, people coming out and celebrating and putting fruit bowls out on the table and having an Are You OK Day, and then the treatment and behaviour never changes.
Yeah, that's true. And also, you know, I think people think it's a bit of a novelty. They'll go up to someone, "Oh, are you okay?" But then what are they going to do if they actually say no?
Yeah.
Is there anything they can do to follow through?
And look, Are You OK Day actually has some very good documents and things that sit behind that tell you how to do it. But sadly, it's not the way it is portrayed, and it's certainly not the way it's portrayed on social media. There is nothing worse than putting the patient on the table, opening them up, and then walking away unoperated on and not sewed up. And merely coming up to someone and saying, "Are you okay?" Being unprepared for the answer, not having a system that sits behind, not helpful. But as in all things in life, what you say is nothing compared to what you do.
Yeah.
And I think managing mental health is a deliberate, everyday thing.
Yeah.
I think when you see the level of support that sits around our office on day-to-day issues and awareness of things, it makes you feel safe. But it is a deliberate thing. Nobody thinks for a second, "Oh, I just heard this about Andrew, I'll go and talk to them." They hear it, they understand, they reflect on it, and they go and do things. So I guess what I'm saying about it is, Are You OK is a good way of raising awareness, but you'd want to have a system beneath it. Otherwise, don't do it. Don't go and ask someone you're okay.
I think it create greater risk.
Yeah, I think so too. So it's probably the first thing. The second thing is just a bit of a trend, Kim, on my usual mad reading of new books that I've read. One of the things that I read about music, because I have a love of music, is in the last 15 years, we've seen the celebration of bands almost disappear and the identification of individual brands. So if you look at who are the top 10 performers at the moment, they're nearly all individuals. Even though their band may say the same behind them, we've seen this drift in American culture to individualisation becoming such a key thing that communities, bands, teams gradually lose their importance. And I see it particularly in underage basketball and things where individual talent is celebrated above team play. Very different from AFL and the way team is everything. But for us, the learning out of all this is, whether we like it or not, we have a generation of people coming through and they're 15, 20, 25, 30, 35, 40, all of whom are inclined to focus on individual outcomes rather than team performance. And I guess for all of us, we need to reflect on that and go, how do we rejig how we measure good in an organisation? Do team KPIs come before individual KPIs? I hope so, by the way. How do we actually instill and embed values? How do we measure behaviour against that? Our organisation, one of our key values is team. And we say team comes before everybody. We don't always succeed in that, but I think overwhelmingly we do. But I just want to raise it with you because it is a trend in music, it is a trend in social life, it is a trend in everything we do, that individual celebration is so profound through social media and through other instantaneous methods of saying, "Aren't I great?" When in fact, to succeed in business, we need everyone to pull together with the purpose of the organisation. So
I do see, especially in law firms, you get that real competitive drive among some of the younger solicitors. I think it can be a very unhealthy thing, actually.
Yeah.
And that's why the team is so much more important.
Well, look, I'm an ex-competitive sports player. I love competition. I eat it up. But I'm very careful that I keep away from it when I'm at work. So I compete for us as a group. And I think when you look at coaching in an AFL level, what you see is everybody in a team understands they have a key role. And the more of a star you are, the higher your expectations of performance are. But everyone understands their role is critical. And that's the same in law firms. Soph, who's actually producing this for us today, Soph wouldn't say she's the most important person, but for this production to go out today, she's more important than us.
Absolutely.
So
we just talk dribble.
We just talk rubbish. So why don't we get on with this case? Why don't we do that? Why don't we go on to Dung Tai and have a look at that case?
Well, we don't have a slide for this one, Andrew. This is part of our introduction.
Oh, this
but
is
you
part of...
hijacked the introduction with these other things.
Well, no, why don't we talk about it? Because I think it's...
Sorry.
Sorry about that. Don't try and find it. I think the story about this is we had somebody, and I'm going to have to try and remember.
No, that's all right. It was quite simple.
It's labour hire.
Labour hire placed an employee or a labour hire with a host.
Yep.
They had an altercation with an employee of the host.
And the host ended the assignment. The host
ended the assignment. Adecco, the host company, still had the job open for him, but he filed an unfair dismissal claim.
They put in 2 medical certificates.
Yeah.
And then 2 weeks after the unfair dismissal claim, Adecco, could be said somewhat cynically, offered another assignment. But what the commissioner said at the end of this, and this was somebody saying I've been unlawfully terminated, said, well, look, the assignment continued.
Yeah.
You're the one who frustrated with medical certificates. Yeah. Capacity is not an issue. Yeah. And everyone understands there's a risk shifting that sits in the labour hire industry, which is if the host rejects you, they can.
And they can at work.
And the issue is if there is no other assignment, well, your employment is lawfully terminated. So it's an acceptance of what lives. It's not the greatest judgment, can I just say? But what it does say to you is if you're using labour hire, please go through a deliberate investigative process for the rejection of the assignment. That's critical for the labour hire provider.
Yeah.
But once that's happened, the labour hire provider, if they don't have a further assignment, can go because they're always casual. Sorry, no more work. But
communicate.
Yeah, but communicate. Anyway, look, that's so. I put that in because it was just a fascinating case around labour hire. Then I forgot all about it.
Yes.
So why don't we jump onto Dupre?
Okay, now we've got our first.
Yeah. Okay. Now, so put back Dupre. I like it. Kim, tell us about Dupre.
Oh, okay. So the company wanted to transfer a number of employees to related entities and have them sign new employment contracts. But the owner said, if you don't sign, we'll treat it as a resignation.
Yeah.
And then one didn't want to sign because he had much broader restraints and much higher sales targets than what he'd had previously.
Yeah.
And the employer says, well, off you go. You can leave the premises immediately.
And by doing that, can I just say, when there's a transfer over, and so this goes directly to Loon Horwath and Crow Horwath in cases like that, that transmission fails where you increase, where the offer you make is not the same as what you had.
Yeah.
And by doing so, it's repudiatory conduct. And so you can accept that repudiation, and then you have future damages, current loss and future damages, which is what happened in this case. So small, discreet little case following Loon Horwath, although not mentioned in it, but fascinating set of facts. And it just shows you as you transmit a business, be careful.
Yeah. Okay?
Yeah. Let's have a look at what we've got next. Now, I think, if I'm right, it's Frost, isn't it?
Yeah, this is right.
This is, I've got to tell you, this is a decision that troubles me, and I don't think it's a great decision.
No,
this was a guy who unquestionably behaved poorly, particularly to a woman, but also to others over a 3-year period. They, in dealing with the disciplinary process, they had to assign him to somewhere safe, and the closest place they could find was 350 kilometres away in Dandenong. I don't think so. No. But anyway, that's what happened. And what the commission said is, look, 350 kilometres is reasonable. And that'll go to the person's individual circumstance and a whole lot of stuff. I don't think this is a great decision. No. And I really think if this was a decision that's appealed, there would be enormous difficulty around whether this was a reasonable adjustment to be made in the circumstances for redeployment. But the answer was his employment could have been terminated because of his conduct, and the problem for Ambulance Victoria is condemnation, that they'd allowed this to go on for 3 years. So I think they've got some problems. There's much more reasonable things they could have done, like stopping his behaviour. I don't think this is a great decision, and I don't think it'll be followed. So I don't think this is something you think is a good idea to move someone 300 kilometres. Don't do it. Yeah. All right. Why don't we talk about Spotswood? Okay.
So we've got an 8-day late unfair dismissal application for a guy who was terminated because he failed to disclose. Well, the right case, yes, I have.
Yeah, no, you haven't. Can I just say the commissioner in this case clearly came to it with a particular state of mind, which was this was a sex offender.
Yeah. Oh yeah. I've been in front of this commission. She's tough. I don't want to be there again.
Yeah. So this was a sex offender who changed his last name to avoid the consequences, and had Had he disclosed the nature of his conviction, he would not have been employed, is the short answer.
Yeah.
That really has nothing to do with the late lodgement,
No.
but it invaded her judgment and it is flawed. What did happen is he said, I was in such a state over the whole thing that I just couldn't get my act together, and his medical evidence didn't go, and this is the only issue that matters in the case, to incapacity. He was able to register Centrelink and other things. But can I just warn you, when you're going in front of commissioners, be aware they bring their history with them. Her judgment is right about this, in the sense, in a bigger picture, this guy would not have been successful in being employed, and it probably was a fundamental breach of his contract of employment not to disclose it. But there's no evidence as to what questions were asked and whether he misled them or anything. So it's actually an irrelevant matter that should never have appeared here. It's certainly in the context in which it did. But beware, whether you're an employee or an employer, know your commissioner. Yeah. Okay. Yeah. Next, let's. What have we got next? I'm always interested to know what's coming up next. It's been a busy week, hasn't it?
Yeah, you're always jumping ahead.
Okay.
Oh, I'm really surprised at the low fine for this one.
Well, part of it's an individual. So this is a single business. This isn't a company.
Yeah. Okay.
So it's a guy who organised some scaffolding to be raised. He hired it. It was too high for what was needed as they were dismantling it.
No, but it wasn't even erected by licence.
No. I was coming to it. He got his own people to erect it. Then he got his own people to pull it apart. And as they were pulling it apart and passing a 25 kilogram part down, somebody fell 5.4 metres.
Yeah.
This is the building industry. Can I just say, this is such classic building industry stuff. The important part about this $100,000 fine to the individual who ran the business, and clearly a breach, not using licensed scaffolder, an inherently dangerous process, no proper procedure. It's all the things that we talk about every week. But what it's showing is both regulators and courts are now after individuals. An individual trader 10 years ago would never have been even prosecuted for this.
Really?
No. We never have touched an individual. They went after larger business, never individuals. But here they've gone after an individual, and it is a first up substantial fine. It's big news. Okay.
Oh.
So we're just telling you, because if this was a company that did this, if this was a building company, we'd be looking $300,000 or $400,000 and potentially reckless endangerment. So once again, remember, regulators start thin end of the wedge. Single small prosecution on a particular target. If you're an individual out in the building industry, watch out, because you're in trouble next time. This is the warning shot across the bow. Okay. And now I think we're on to medical cannabis.
No, we've got another one.
Got DPP and Martin's case. Yeah. Sorry, I forgot all about Martin's case.
So this is another one where lack of different situation in that the company was quite diligent.
It was a diligent company, but this was something when people were up on the top of their trucks. There was a protective part to prevent fall, and it wasn't properly fitted. And there wasn't a testing process to identify that level of risk. And court was incredibly generous, I thought, towards Dean and Martin, and saying, look, you are a good employee, you do the right things, but this is clearly a gap in your process. And it's a high risk gap, because people climb on trucks all the time. So you've got to deal with it. But their fine it shows the tariff in Victoria is gradually going up. So this was almost a faultless business. Good history, good everything. $350,000 fine. Would have been $500,000 without the early pleading guilty. What it shows, Victoria tariff, like New South Wales and Queensland and South Australia, Western Australia, still a bit early to tell at the moment, the tariffs are going up. And so we're seeing this gradual growth. You've got a fatality. You're near perfect in Victoria. You're at 350 with an early plea of guilty. That used to be 5 years ago without an early plea of guilty, the tariff. So we've gone up on the bottom about 150,000. What that means at the top end is you're looking $1 million. You're starting to get it. Used to be 650, 700. So I just want you to understand fines are going up. In the sense that the fines are set, but what courts are willing to order and what is being pursued by the regulator is now higher. All right, that's Martin. We've nailed that. Now can I do medical cannabis?
You can. It's a good case as well.
DP World, always interesting. It's obviously dealing in the maritime industry as well, which is a complex industry. This is a person who failed to disclose that they were using medical cannabis for mental health reasons. There's very strict zero tolerance in relation to drug and alcohol levels, and it was high risk work that was being undertaken. DP World terminated. it was successful.
After a positive drug test.
Positive drug test.
Yeah.
What I can say to you, and I think Kim, Nina and I are all pretty concerned with medical cannabis, is there is a lack of structure sitting around medical cannabis use, and understanding there's a lack of science sitting around what is the impact on judgment. So we're in this hiatus at the moment where the THC levels will come through, but we don't understand the level of impairment. We never really understood thoroughly the level of impairment with illicit cannabis use. And seeing as it goes to being under the influence or unable to undertake their tasks, those sort of tests that are being applied, it's pretty unhelpful at the moment. And I guess we're going to talk about policies and procedures again next week, and about the failure to actually properly consult on policies and procedures. When it comes to drugs and alcohol, please consult, have good solid policies and procedures, because the medical evidence and the scientific evidence around the levels of impairment and judgment are not clear in most drugs, but particularly with medical cannabis. So,
and the doctors don't know.
No, they just don't know. They don't know.
So I have come across one in New South Wales, an expert
on
this area. So
but even he was cautious when sorry, this was in a case that we're dealing with. He couldn't give us clarity about what impairment of judgment looks like as a percentage of impairment, or something that was concrete to give us. So please, policies and procedures are everything. All right, this is the dead dog story. This is
well, it's not just a dead dog story, but
that's what affected me. So this is a guy who was on a learner's permit and was allowed to drive by his employer. He knocked over a couple and killed their 2 dogs. The guy was okay. The woman went into critical condition, but the dogs died. To me, he should have been shot. Anyway, he wasn't. This is in the Northern Territory. It could only happen in the Northern Territory. If there was a dog sitting as a judge, they would have had him put down. He would have got the green needle. But it didn't happen, okay? But clearly an organisation that permits an unlicensed person to drive mobile plant, which includes car, is in a lot of trouble. There's been breaches here. We haven't got the final determination of what the sentencing will be, because it's just the charges that are happening. But be aware, this is such an explicit case, isn't it? Because you've got driving a car and you're not licensed. How could you ever let someone do it?
But what gets me, it was the son of the director.
It always is. It always is. Northern Territory. Anyway, but it's just the same as an unlicensed forklift driver. It's just the same as people who have license to do work. And yet that's so common. So be aware, this is the way courts will look at it. They've been charged under 3 provisions in relation to this. Because it's so obvious, because it's a license on a car, but it's just as obvious for a license for a forklift. Okay? And for the dogs, I'm sorry to hear your passing.
Puppies.
That'd be in our newsletter. We have a pets area in our newsletter. Whatever, a picture of the driver with stab marks. Okay, time for the main topic. Okay.
Oh, dear.
I reckon the Peabody case is a fascinating case. Okay. What we're talking about today is, it is common, particularly in industry now, where if I looked at our business, parts of our business are done by contractors, some in Australia, some externally. It's necessary in business to actually make money and to have proficiency, because of the talent shortage in Australia, to actually use contractors, sometimes in Australia, sometimes externally, to actually fill the workload and talent load that's required, and have the flexibility that's necessary to meet fluctuations in demand. Now, why am I ranting about that? Well, the answer is the world's not a bloody easy place to work in. And the best businesses have huge volatility in what they're selling, doing and achieving. So the Australian award-based structure is not fitting a global practice. Just to be real, it just doesn't work. And we struggle. We have seasonal variations. We have times, because our Reserve Bank doesn't seem to care about us much at the moment, where there's a downturn in work in certain parts of our department. The world is so much more volatile than it was 20 years ago. So contractors are a key part. Peabody made 22 people redundant. And as part of doing that, there was a complaint raised by the union that in the consideration of redeployment, the removal of contractors was not considered. At first instance and in the federal court, an argument was held, and it was accepted that Peabody could adjust if they wanted to. What Peabody said is, nice call, but it's all abstract. You didn't actually enter into our business to understand what it was like. We put the evidence before you, but you ignored it. You just assumed we're a large organisation that could adjust, and you've got contractors, surely you can take them up. they've got special leave in the High Court on this issue, whether you can objectively say it was reasonable based on the evidence that is before you without taking into consideration how the business runs, or whether you need to go to a subjective consideration of how the business actually is run and the importance of those contractors.
Yeah.
But it is a huge decision when it comes through, because every time we deal with redundancies, Kim and I will go, okay, give me the list of casual skills, competence, give me the list of contractors' skills, competence. And we go through this process of trying to work out what it is. And if you're an Australian-wide business, we start looking all over Australia to determine where those gaps are filled. What Peabody is saying is, you look at our business at the time of making the decision, we couldn't do it.
Yeah.
It was not possible. So I think it's just a fantastic case. And I'm really glad they've agitated, and I'm really pleased our High Court has taken it on. The High Court will look on this very favourably. We've got a clever black letter High Court at the moment who will give meaning to the words that sit in the redundancy provisions, and they won't hide from being courageous about it. And they will say, I'm almost certain, they'll line up with Peabody and say,
I think so.
You've got to look at the circumstances of the business. You can't just force a business to actually deploy people for which there aren't roles. It'd be great if it happened, wouldn't it?
Yeah.
Why don't we jump on? We've had a lot on today, so why don't we go on to the case study? Yeah. Can I just say, next week is such an exciting week. The cases that have come through in the last 2 days, we often have cases because they're funny, naughty, got dogs dying, all sorts of things. But next week, they're all really important cases for actually how you practice. So beware next week. We've also got the new legislation that Albanese is putting through about doxing and all that sort of stuff, which we'll talk about. But let's go now to our problem, because this really exposes a number of issues.
Okay.
All
right. Deltoid Lifts Proprietary Limited, or DL, built and maintained multi-level lifts for commercial premises throughout Australia. Diane was an electrical engineer employed by DL in its Brisbane office, who regularly worked on site along the eastern seaboard. The Brisbane office had been the foundation office, and up until 2021 had housed the design arm of DL. Changes in technology made it difficult for DL to recruit highly skilled engineers who were across the rapid adoption of innovative use of AI for people logistics with lifts. That's a very tough long sentence.
That was for Nina, wasn't it? Yeah. I thought Nina was doing it. She would have got lost halfway through. I would have won with her. She would have killed me, but it would have been fun. Okay, next, keep going.
The spike in commercial building in Melbourne and Sydney meant there was an immediate need to bring design functions into those two offices, with a requirement for front-end expertise on site every day in installing
and calibrating
of technology based on site needs. Diane's boss, Chuck, was a true engineer. Every issue was detail-rich. He went down every rabbit hole. It drove Diane and others crazy. But Chuck was one of the founding members of DL. His acquired knowledge and focus on customer service was legendary, despite his inclination to micromanage.
I think there's more, yeah.
Diane had raised with HR that she felt unsafe with the way Chuck worked. It meant that she had no control of the hours she worked, literally in a day and overall. In addition, he was a procrastinator, which meant workflow around deadlines were awful. Diane was lucky her husband had a 9-to-5 desk job and could look after their teenage kids, but it was starting to affect her relationship with her husband and children. HR approached Chuck about his behaviour. They had heard it from others, but only told him about Diane. He blew a gasket when he heard. He explained to HR he had kept her going in Brisbane when there was actually no need out of respect for her, but they needed the engineers in Sydney and Melbourne, and his paper was currently with the executives to move design to Sydney and Melbourne. 2 months later, the executives approved. See, that's my tooth not working well.
That's right. I didn't know about the tooth when I did this. I would have had a lot more S's in it. I'd have known about the tooth when I wrote this.
2 months later, the executives approved Chuck's paper. Chuck was designated as the decision maker. There's a lot of S's in there. For all terminations of employment arising out of the decision, and he was the National Operations Manager. Diane was approved by Chuck. Approach about her role in Brisbane being redundant, but offered redeployment in Melbourne along with a $50,000 relocation package. Sorry, everyone.
All right. Don't worry. Brisbane would retain 3 design engineers with IT focus on a contracted basis, but otherwise would have no permanent employees, and the office would be closed and everyone would have their teeth removed. The contractors had different skills to Diana. Diana's salary was 160 plus super. Diana refused redeployment as it was not reasonable for her and her family. Her husband was paid very well for a company that had no office in Melbourne and there was no similar work available. There we go.
Sorry.
No, you did very well. Was there any breach of safety law and would anyone be charged? I'll help you with this. Yeah. So the issue here was Chuck's behaviour. Okay.
Yes. Diane raised complaints that she felt unsafe.
Yeah. So if we look at the sort of things that he's doing, micromanagement doesn't sound like it's a safety breach, but it's quite clearly a safety breach, and procrastination when it leads to excessive workloads, lack of planning, lack of clarity around life. There are significant psychological hazards. Nobody be prosecuted, I don't think, but it's worth saying that it damages the productivity of the business, and there would be if Diane developed a psychological injury as a result of it, then I think the level of chance of a low-level primary duty breach are real, and probably in Victoria, a Section 25 breach against Chuck as well, a similar versions on the WHS. So low level of risk, if psychological injury occurred, higher chance of prosecution, but low level of prosecution because Chuck's a good guy doing the best he can. But let's go back to what good leadership looks like, okay, because he's damaged the business. Is Diane an award-based employee? And if so, was Chuck's requirements what was Chuck's requirements in the award? Did he comply? Yes, Diane is probably under the manufacturing award or the construction award, depending where it falls, as an electrical engineer. Therefore, the consultation requirements that set out in Clause 9 customarily in awards applies, which is to consult once a decision has been made and to avert and avoid and mitigate the damage done to a person. So the consultation wasn't flash with Diane on any version of the facts there. There was an attempt to avert or mitigate by offering a relocation allowance, but a failure to actually understand her personal circumstances made it a nonsense. So there's an award breach that sits there. How does that go to termination? It means it's not a proper termination. It's an unfair termination that would occur. So she'd have a very good claim for reinstatement. They'd have to prove that there is no role. Now the issue then comes back to the contractors. Okay, could have she been redeployed? Could have they got rid of a contractor? And here's the argument. This is the Peabody argument. Well, we did have 3 contractors, but they had different sets of skills. And they were critical for the business, and we couldn't get them anywhere else. We just got them wherever we can, those skills. If we get them in Melbourne, Sydney, we'd get rid of the one there because this is where our primary business is. So on Peabody, I think what you'd end up saying is no chance of failure for genuine redundancy. Without Peabody, there's an argument that sits there because it's a large interstate business, acts nationally, and there are contractors. So I just thought we'd flesh it out and see what happens. Was the offer of a job in Melbourne with relocation's expense a reasonable offer? The answer is no, because they failed to look at the personal circumstances of the husband, and they would be significantly worse off as a result because he'd have to lose his job. So no.
And you wouldn't get teenage people moving.
They're not easy, are they? No. So DL's obligation was, like it always is when you look to relocate or to redeploy, is to look at the individual circumstance of each individual, including their family circumstances, like getting children to school. When it was one of the child in VCE, for instance, no way moving would be a reasonable thing to do. So remember, as you go to redeploy, set up a matrix of facts that relate to the person's life, how far away they live, where their role sits, can they travel interstate, is it different obligations interstate now that you require them daily on site? Because we know that she was already travelling interstate. So it doesn't seem to have been a problem. I think they're in real strife. Okay, let's go to now over there. Does Diane have a general protections claim or unfair dismissal? I think she definitely has an unfair dismissal claim, and you can't help thinking that part of the issue that sits behind this, the subjective test for Chuck, is did she hit the radar as a result of her complaints made about Chuck? Now, that's a reverse onus that Chuck has to... So you'd have a look at what was the plan that he put up, and then what was the plan that was accepted. So the evidence of the decision will be critical. And the interesting part about this, which is always interesting, is usually the decision has been made months in advance, and there will be emails and correspondence internally that proves that. And then it's the whole architecture of this is fabricated to make it look like a general decision was made at the last minute. I think it's unlikely to be true. So I think Chuck could be in trouble and can't show the organisation the general protection stage, but certainly unfair dismissal. What has happened is an unfair dismissal.
Yeah.
Could Diane have made a workers' comp claim, Kim?
Yes, she could have, if she could establish a mental injury, definitely as a result of Chuck's failure.
Yeah, and remember the mental injury test is higher in Victoria than it is in Queensland. So it would be easier for accepting, and the state regulation in Queensland is accepting all over again very, very quickly in Queensland.
Yeah.
It had a quiet period there where it didn't do that about 2 years ago, but it's back doing it again, isn't it? Anyway. Could Diane argue a breach of safety discrimination law as she raised a safety issue and nothing was done about it? So in every piece of safety legislation, WHS or OHS, there is an anti-discrimination provision that says if you raise a safety issue and your termination arises causally, is connected to it, then there is a personal discrimination, which goes back to Patrick's case. I think she's got an argument. Now, why is that a good argument? Well, this is a business that does not want the safety regulator inside its business. So it's a lot of leverage. So I think she's got an argument. Yeah. So there's an interesting case. Look at all the different causes of action that exist, all the different risks that sit there, all for Chuck being a jerk.
Yeah.
Really?
Andrew.
Yeah. All right. See you later, guys. And thumbs up. Next week is very exciting. You back here next week?
I hope not.
You could do.
If
you do, there'll be lots of S's. There'll be and S's all the way through the problem.
You'll be an arsehole.